Part 3. Civil and Criminal Charges. Whenever you receive a traffic ticket, citation, summons, complaint, indictment, etc., what you receive is a public offer. It is an offer of indebtedness to your straw man. It is conclusive presumption, in other words, fact, that your straw man is obligated to provide the funds if you act in dishonor. In commerce, the penalty for being in dishonor is losing one's equity. Remember that no court in the system, since they are all in the public realm, can see, address, or deal with the real you. Public courts can deal only with assumptions and fictions in their colorable, phony system. As such, there are no facts other than what is stipulated to by the parties. Agreement. If an adversary says the sky is green and you agree, that agreement constitutes a fact. The commercial tribunals of the system are all contract courts, and your stipulation is contractual ratification, which is the law of the matter. People lose in the courts because they try to counter or neutralize one assumption with another. If you are in dishonor, you'll be forced to provide through your straw man public funds, Federal Reserve notes or equivalent, one way or the other, to satisfy the obligation. This can be by simply parting with Federal Reserve notes, doing community service, or by being incarcerated as the surety for the obligations of your straw man. In the latter case, they create the bond by further borrowing against your straw man. This generates funds that are used to balance the books and also make considerable additional money for the courts, judges, attorneys, etc. Given the immensity of money made, per the Comprehensive Annual Financial Report and the Long-Form Annual Financial Report, which is several times the total amount of the entire economy of the private sector, the mania in the United States for charging, prosecuting, and incarcerating is understandable. The following are important considerations in the equation. Number one, as investors in the bankrupt corporation called the United States, as well as the United States of America, the parent corporation, we, as real people, are the true creditors of the country and source of the wealth as discussed above. As such, we are exempt from taxation from the public side. The creditor and sovereign cannot be taxed by a system that functions by using the credit of the creditor. The public side is debt, operating by borrowing against us. Being derivative and dependent, the tail cannot wag the dog. The reflection cannot dominate the reality it reflects. The system does not deal with us as real beings. It deals with a fiction, a symbol, which is not us and therefore does not require the system to deal with us as the creditor and sovereign. Moreover, the public domain can tax and regulate only what is created in and belongs to the system, which can be only straw men and never real beings. Number two, as creditors, sovereigns, and true owners, preferred stockholders of the country, we have authority to offset any obligation imposed on our straw man by the public side by making our exemption, which is unlimited, available to discharge the charges. The source from which the obligation was derived is our own credit, which can therefore be used as the asset to offset the obligation created by borrowing against that credit. The size of the purported obligation, as well as its severity, is technically irrelevant. That which can be invented in the form of an alleged obligation can be offset, in other words, discharged, with the same ease as the obligation was created. All public debt is nothing but numbers, digits in the matrix. Promissory notes, creating currency by signature, got us into this mess. Promissory notes can get us out. Footnote 16. It is often considerably more difficult using the acceptance for value process for dealing with matters involving a mala in se crime than a mala prohibita offense. Although all crimes in the system today are commercial crimes, see 27 U.S.C. 72.11. Number four, the only way we can discharge and offset such charges completely, neutralize and eliminate them totally and close the accounting, is through an acceptance in return for value through the use of our exemption, which we make available to be used for exchange as the funds for discharging the obligation/charges. Per the maxim of law, a thing is bound, so it is unbound. Number five, when we, as the creditor and sovereign, proceed as above, we are functioning as the king. The colorable public side is rendered dependent upon and subservient to our acts. By law, public officers are fiduciaries and have no discretion. Compliance is mandatory. It is unrealistic, of course, to think that those who structure and operate the system for commercial enrichment and power will go gently into that good night when we use the system for our protection and betterment. In addition, and of crucial importance, it is to neutralize the unrevealed presumption on which the system operates that we, the real us, have agreed to be united with and treated the same as our straw man. We remove that presumption by noticing the proper parties of the foundational documents referenced below. Many times when these documents are placed on the record in a court case, the case disappears. If they cannot access the real you and your body, labor, and property, they are left hanging out to dry in their cloud cuckoo land. What to do upon receiving a presentment? Receipt of an offer presentment will occur in one of the following ways. Number 1, by mail. Number 2, in person. Or number 3, after arrest and being placed in custody. Herewith below, we will concern ourselves with the first two modes of receiving a presentment. Number 1, as soon as you receive an offer, such as a bill or a statement you wish to discharge, make a copy, preferably a color copy, certified as true and exact copy by a notary, of the offer, and keep that copy in a safe place. If you're already in court, go to court and obtain at least 2 copies certified by the court clerk of the documents filed in a case by the other party. Then use these as you would an ordinary presentment, following the procedure set forth hereunder. Number 1, after making a copy of the essential documents issued by the other side, and print over the first page of the original of each document the following text. There are numerous versions of this and opinions as to which is best. This presentment is accepted for assessed value and returned in exchange for settlement and closure of this accounting, certified and sworn on the commercial liability of the authorized representative as true, correct, and complete, with all related endorsements front and back, prepaid, exempt from levy. Adjust the account and release the orders to the authorized representative immediately. Autograph, postage stamp, 2 cents, US is okay, and then dated. Number 2, if you've had your bullet stamp made, which includes your full name in upper and lower case, some people use all lowercase letters in their documents for ancient linguistic reasons, as well as your EIN number and the term stating that you are operating in capacity of being the living principal and authorized representative, stamp your bullet stamp in gold ink so that it is over part of the accepted and returned for value, in other words, ARFV stamp above, and also across the upper left-hand portion of the postage stamp. Footnote 17. There appear to be 4 alphabets in English. Print, including uppercase letters in whole or part. Print in all lowercase letters, uppercase cursive and lowercase cursive. Allegedly cursive handwriting joins phonetic symbols in a way that removes their individuality and therefore does not certify the pronunciation of your name, voiding capacity for your autograph to state a claim. This is why one should always also print his name, thereby having a double witness and removing ambiguity, which may be construed as fraud in law that may require a third party, in other words, a judge to adjudicate. Also, language, multiple languages, in other words, Babel, as in the Tower of Babel, came from the ancient Phoenicians and was, among other things, developed as weapons. Writing in all lowercase letters was allegedly the mode of writing used by the elite, whereas use of all capital letters was reserved for ships, dead fictions, and slaves. One may review the term Capitis Dementia Maxima in Black's Law Dictionary 6th edition concerning this matter. Number 3, autograph your name at a diagonal across the postage stamp so that your autograph is done over a part of the acceptance return for value text. Across the postage stamp and on the presentment itself, use blue or purple ink. Put in the date by hand. Footnote 18. A long-standing concern about what color ink is best to use for such things as signing a document with an accepted for value stamp has been recently resolved by this author, who has now concluded that red is not good. Blue or purple is optimal. Rather than indicating blood and the living being as we had thought, the significance in the color scheme of the system indicates that red expresses deficiency, such as being in the red. Number 4, if you do not have your bullet stamp, use the postage stamp as above, autographing on the diagonal across the stamp, filling in the date, and also printing your EIN number as per the following. This presentment is accepted for assessed value and returned in exchange for settlement and closure of this accounting, certified and sworn on the commercial liability of the authorized party as true, correct, and complete, with all related endorsements front and back, prepaid, exempt from levy. Adjust the account and release the orders to the authorized representative immediately. Autograph, 2-cent postage stamp, and your EIN number. Number 5, your package to the offer will consist of A, a verified notice by affidavit notarized that informs the presenter of what the documents are that are attached or enclosed, what is required of the presenter, notice that the notary retaining a copy of the documents being sent and is acting as a disinterested third party, and that if the presenter does not respond to the notary within the required time, 10 days in most cases, with notice that he has adjusted the account and the obligation is discharged, a certificate of non-response will be forthcoming from the notary that constitutes a notice of dishonor and judgment and estoppel on the law. B, your acceptance and return for value presentment, signed and dated by you in blue or purple ink and bearing your private treasury UCC contract trust account number, which is your social security number without dashes. Number 6, if the notary does not hear from the offeror within 10 days that the discharge has occurred and the accounting is closed, have the notary send the offeror a certificate of non-response. This constitutes a certificate of dishonor and a judgment and estoppel on the law, which bars the offeror and everyone else from ever coming after you again concerning the issues in the offer. If a court case is involved, have your notary also notarize such things as the following. Number 1, certified copy of the oath of office of whatever judge is involved, if the identity of the judge is known at that point, as obtained from the Secretary of State of the state or the county recorder or whatever office is holding it. Number 2, notice of waiver of protest. This document requests the court to waive any fee, fine, cost, or charge the court is looking for. A default position by the court is automatic record of involuntary bankruptcy if the court dishonors your request, as the living principal and authorized representative for your straw man. Your notice informs them that their dishonor constitutes a waiver of right to protest the matter or anything connected therewith henceforth. Number 3, notice of acceptance, standing, and status, request for remedy. This pleading format document instructs the court to discharge all charges and dismisses the case. Based upon your acceptance and return for value of the charging instruments and all court documents, along with filing the bond, or in the alternative, produce the assessment for the charges, whether the charging instrument is a citation, complaint, information, statement, or indictment. See instructions for executing and using employer ID number B3 Supra. It is an automatic dishonor forfeit position if the court does not provide the assessment for the charges if you require it. Substantiation of the bona fide nature of the assessment consists of providing the commercial paperwork that reveals the origin, nature, particulars, and legitimacy of the assessment which, to be genuine, must be executed by the responsible party under affidavit sworn true, correct, and complete, with stated commercial liability risked by the responsible party in case he is found to be in error, and swearing to the accuracy, relevance, contractual validity, and verifiability of all allegations made and the exactitude of the sum certain amount of the assessment. Failure to put up or shut up in this regard signifies the court stipulation that it is continuing to entertain prosecution of non-existent charges. Number 4, bond. 2 options. A, single-page bond on court pleading format. This bond is filed in the court on court pleading format. Such format renders the document more familiar in appearance and therefore more easily filed than trying to file papers that are not in pleading format. Elaboration on the bond, its use, and history of success are discussed hereunder. Or B, request for appearance bond. This document is a court brief that instructs the court to have an appearance bond issued at no cost to you in order to underwrite the case and the appearance of your straw man at scheduled court hearings. The court's failure to issue the bond allows you to utilize the dishonor obstruction as a grant of their signature by accommodation to be used in the subrogation surety bond. You notice the court that you're requesting an appearance bond backed by your exemption on the private side at no cost to you. Technically, the granting by the court of your request discharges all obligations connected with the case, ends the dispute, and makes you the owner of the matter. At this time, we are awaiting final outcome of using this process. If the matter is a commercial bill, such as a credit card statement or other invoice, and they ignore what you have done and continue sending you more invoices, treat each new bill as an original presentment. Each statement is another offer on which you can do the same process. This is true of any matter, such as mortgages, credit cards, etc. The offerer's non-response signifies his tacit stipulation that he owes you the amount on your bill. He has implicitly agreed that he owes you the funds by not responding. He has invoked the doctrine of acquiescence and estoppel by silence. As valuable as a judgment in estoppel on the law is, it is not the best we can make of a situation. We would like to make money from the event. For this, we need a second judgment in estoppel, one on the facts and the money. When you do this, you establish on the record the amount that the offerer owes you in cost, fees, and damages. The amount can be anything you choose, since only you can decide what you think the matter is worth to you. Besides, it is all nothing but digits in the matrix. If a court procedure is involved, as soon as possible file a court brief in standard court pleading format entitled Notice of Acceptance, by which you notice the court of the following. Number 1. You've accepted the charging instrument for value, banker's acceptance, and returned it in exchange for settlement and closure of the accounting concerning the matter. Number 2. Settlement of the account has been done privately by exchanging your exemption for discharge of the obligation by use of your private treasury UCC contract trust account, your social security number without dashes. Number 3. You are operating in capacity of being the living principal, authorized representative, and attorney in fact for the straw man. As exhibits/attachments to your notice of acceptance include color copies, preferably certified by a notary as true copies, on the following foundational documents. Number 1, employer identification 1. Number 2, private agreement. Number 3, security agreement, pains and penalties. And number 4, your international hold harmless agreement. Also file a notice of request for waiver, and number 2, a notice of request for remedy. Put an autograph and bullet stamp postage stamp on the back lower right hand side of every page of every court brief you file. Obtain multiple copies of your documents to the court and have the clerk file stamp them all. If the case is not dismissed, which it usually is, file the court bond. B. Explanation of the process involved in accusation and prosecution. The situation involved in having to appear in court is as follows. Private substance fact. Existential event. Subjective interpretation by accuser with alleged injured party and claim of mens rea, criminal intent. Public reflection interpretation. Statutory criminal charges. Civil resolution by agreement of the parties. The sequence is this. Number 1, you commit some actual act, such as writing a check on a closed account, which is simply an event in reality. You inscribe something on a piece of paper. So what? You also walked to the grocery store, ran into a friend, and planned a dinner party. All are simple happenings with no legal charge attached. Number 2, someone, some living being, the complainant, has considered what you did to be a crime you committed with criminal intent, mens rea. In other words, out of an infinite number of possible subjective inner motivations you might have had for doing something, and an infinite number of possible ways anyone can think about what he perceives of your action, the accuser chose to adopt the perspective that what you did was a crime that you committed with criminal intent. The first is a value judgment. The second, regardless of substance, is nothing for which anyone but you possess authority to speak. The accuser can neither know your intent, nor does he have any right to speak for it. He can observe your outer behavior, not your inner motivation. Number 3, the interpretation that what you did is a crime, as well as what that crime is, what statutes you allegedly violated, the basis of prosecution, etc., are all applications of the facts to the accuser's presumptions, assumptions, priorities, interpretations, and motivations. Number 4, the complainant swears out a complaint under affidavit that you did what he says you did and submits it to the prosecuting authorities for them, as public servants, serving the system, not you, to investigate and thereafter prosecute your straw man, with you attached unless you rebut the presumption on the contrived union. Number 5, the first thing across the mirror, the bar, onto the right-hand side of the bar, in other words, public debt bankruptcy mirage land, is the criminal charges, which is what the public side indicts you for. Since the public side is debt, reflection, and bankruptcy, nothing of substance and reality can originate there. The public side must reflect something real on the private substance side and then adjudicate the imaginary dispute concerning the arbitrary interpretation of the actual event, calling it a crime and saying it violated one or more of their statutes. The event itself is nothing other than an occurrence in reality, a thing in itself that is completely neutral. If someone calls it a crime, that it is his projection, interpretation of his mental processes and priorities. What he makes of what you allegedly did is his business, not yours. What do his mental processes have to do with you? He is manufacturing fiction and projecting it on you, attempting to lure you into traversing into his imaginary, let's pretend world and deal with what goes on there. You receive a complaint that says, on or about June 5th, 2001, John P. Smith, you, did willfully do blah, blah, blah. So you read this, blush, and say to yourself, angered and fearful inside, that dirty rat, I did not. If you join his game and try to disprove his fiction, you have left your domain, departed from solid ground, and ensconced yourself firmly into a swirling mirage of your accuser's fertile imagination. Why write yourself into his novel? 6. In a criminal case, the system functions by getting people to plead to the criminal statutes on the public side. Then the matter shifts from criminal to the civil agreement of the parties for resolution. If you take this route, you are down the drain. The proper way is to obtain a civil, meaning money, resolution on the private side so that the dispute is ended at its source and there is no controversy for any tribunal to resolve. This resolution occurs by stipulation between the parties as real beings. Once that agreement is reached on the private side, the origin, the possibility for any public action is eliminated. There is no longer anything to drag across the bar and into the public domain. Number 7, for securing the stipulation between the parties that ends the dispute on the spot, admit to the facts in the charging instrument, after having accepted everything for value, of course. This can be accomplished by a statement such as, I have no problem with pleading guilty to the facts stated in the charges. The prosecution says you wrote a check on a closed account. Okay, you did. That is a fact, not a charge, so agree with the statement. By so doing, you are not agreeing that what you did was a crime or violated any statute or can be any basis for prosecuting you. You have merely agreed to a fact in reality, thereby reaching a stipulation with the prosecutor that ends the negotiations. Because there is stipulation between the parties, there is no longer any controversy for a court to hear and entertain. The agreement between the two of you ends the matter. When there is agreement on the private substance side, the subject matter can never get to the public side because no dispute exists. Number 8, concerning the bonding of the case, your discharge of the matter by use of your exemption makes you the owner of the transaction. Number 9, keep in mind that if you follow their lure, what they present to you as the way to go, you're dead. They want you to plead to the statutes, not the facts. The statutes are their property, their truth, in other words, fiction, and jurisdiction concerning which you have no authority to deal. You own yourself on the substance side, but have no claim on interpretation of facts that someone alleges on the private side, out of his belfry, that he wants you to deal with on the colorable public side. If a matter is ended at its source, the private domain, there's nothing to bring into the public arena. Number 10, by pleading guilty to the facts on the private side, you're demurring. Who says I can't write a check on my own closed account? I'll place some ink on a piece of paper, but so what? Number 11, remember that no one on the public side can charge anyone with a crime on the private side. Only people act. Straw men do not and cannot act. Therefore, deal with the matters between you and your adversaries privately, forming private contract, usually by their tacit consent through non-response, between you and them. The terms and conditions of the contract include the fact established on the notarial record that they stipulate that the matter is resolved so no dispute exists. Sic transit case. Number 12. Someone invoking the system must post a bond to invoke the services of a court. The authorities cannot arrest you without an order, warrant, which is a check, from a court, and the only way a court can obtain the jurisdiction to issue a warrant is by someone having posted a bond, indemnifying the court and granting the court subject matter jurisdiction, funds against which to execute the warrant/check, to adjudicate the matters you are being accused of. You must require that they provide the audit trail of the accounting on that bond that allegedly bonds the case. Number 13. If you are presented with a warrant, accept it for value, write exempt from levy on it, sign, date, and return it to the court. This grants the court authority to use your exemption in exchange for release of the property. In other words, return of the bond to you as the creditor and insurer. Number 14. The court bond gives the court subject matter jurisdiction. If you are the creditor, paying with substance and not liability funds, it is your court. The court serves the creditor. When you have title to the bond behind the criminal prosecution, there is no way you can go to jail because you have discharged the bond that would otherwise result in your being seized and incarcerated as the surety for your straw man that they treat as the debtor, defendant loser, in a dispute. Number 15. If you enter a plea when no bond has been posted, you have broken the law by pleading to non-existent charges, in other words, color of charges. Also, you have granted the court subject matter jurisdiction to prosecute your straw man on the public side as the debtor. Posting a court bond removes all basis for continuing. The matter is resolved by your discharge on the private side. Number 16. Having a hearing in an admiralty court is not a common law right. It requires posting a bond so that the court can have in rem jurisdiction. The property at stake in the proceeding is the bond. You must secure title to the bond behind a criminal prosecution if you wish to be immune from conviction. How do you get title? There must be an agreement between the parties concerning the identity of the creditor on the bond. The court will probably try to secure title by asking you to pay a small fee for filing the bond. This is a trap. One way or another, you must provide the asset that balances the books. The issue is not whether you discharge the obligation, but what kind of funds, in other words, in asset funds or liability funds, you use for doing so. If you use your exemption, you secure title. If you use Federal Reserve notes, you forfeit title. Therefore, you suggest that either the court waive the public administration fee for registering the bond or secure the fee by performing an adjustment and offset through the use of your private treasury UCC contract trust account, your EIN number without dashes. If the court does not do either, it is in dishonor of you as the king creditor, authorizing you to discharge the matter by bringing involuntary bankruptcy against the court to discharge the bond because you have established yourself as the owner by your acceptance for value and willingness to allow your exemption to be used for discharging the obligation. C. Strategies concerning court. One of the most difficult positions to be in when inside a courtroom is sitting down. It is best to wait outside or in the back of the courtroom until the straw man's name is called. Then walk towards the bar to speak and don't sit down. Sitting is inferior to standing, and if you go through the drill of being in court before the judge enters, standing up upon hearing the bailiff announce, "All rise," and then sitting down when instructed to do so, you are signaling by your behavior that you are an obedient serf and subject of the court and within its jurisdiction. This is not a desirable position. A maxim of law concerning this states, it is immaterial whether a man gives his assent by words or by acts and deeds. When your straw man's name is called, when spoken it sounds the same as your upper and lowercase name. See item sonins, meaning same sound in Black's Law Dictionary 4th edition. When this happens, do not say, "Here." As soon as you give your name, you testify that you're in the public side. You testify that the real you is the straw man/defendant on the paperwork at which the judge is looking. You form a contract with the court by which you agree that the real you may be treated in accordance with the way they treat the straw man defendant. You surrender to the court's jurisdiction. You agree to leave your own ground and domain and go join them on the schoolyard in their let's pretend cops and robbers game. The crucial points to keep in mind in any court interaction are as follows. Number 1, the courts are equity, admiralty, probate, trust courts, not courts of law. In such courts, there is neither law, nor substance, nor facts, nor evidence, nor charges. There are assumptions, presumptions, color of law, color of substance, color of facts, color of evidence, and color of charges. Officials and attorneys execute the paperwork and pleadings as if, let's pretend presumption, your straw man is the trustee, defendant, actually co-trustee of the public Cestui trust created by the 14th Amendment, but the duty and the state, plaintiff, is the beneficiary. In other words, co-beneficiary of the public Cestui trust created by the 14th Amendment, who has allegedly been deprived of his trust benefits by the delinquent trustee. Trustees are always outside common law. Footnote 19. Even the use of the word pay is a trap. We are better off not using it in interacting with the system. Since there is no money, but only debt currency derived from borrowing against the people, there is no way to pay a debt. We discharge obligations, not pay debts. Footnote number 20. The Cestui Trust is a public charitable collective trust, or PCT, that is constructive and not express. Constructive means that the trust is constructed, created, manufactured, concocted by operation of law. In other words, out of nothing, as just another of an unaccountable number of legal fictions on which the entire system consists, by the whim and fiat of those who own the particular law form in which the trust is indentured and domiciled. In the case of the United States, this jurisdiction is the private, commercial, international, military jurisdiction of the original incorporation of the United States Incorporation in 1871, within the 14th Amendment and emergency war powers implemented at the advent of the Civil War, the suspended law, and terminated thereafter operation of the de jure government under the original charter, the 1787 Constitution. A citizen of the United States was created by or within the 14th Amendment as a corporate, civilly dead entity operating as a co-trustee of the public charitable trust. The 14th Amendment upholds the debt of the United States of America and U.S. Incorporated. And Section 4 of the amendment, which states that the debt shall not be questioned. That is part of the terms and conditions of your co-trustee position. If you question the debt, you are in violation of your own contractual obligations. Endeavoring to find fault with the system or any of those operating on its behalf is considered as arguing against yourself, which every judge immediately dismisses as self-evident error, if not insanity. No wonder judges are so fond of ordering psychiatric evaluations for those who appear in court these days. It is presumed that everyone who states that he is a citizen of the United States Incorporated, or acts as if he were, has knowingly, intentionally, and voluntarily contracted into the private, military, international, commercial, admiralty, equity law form of the 14th Amendment Public Charitable Trust, surrendered all rights, and agreed to be bound by the alleged resulting contract. One is now on the ship, where the captain's word is law, and trying to protect your rights, find the system in error, or walk off the job is walking off the plane. In the Public Charitable Trust, every citizen of the United States acts in a dual capacity, as co-trustee and co-beneficiary. This means that as a citizen, you have on the one hand, as co-trustee, obligations and duties such as the requirement to comply with all the system's codes, rules, regulations, laws, statutes, and public policy, and on the other hand, where in the hat of co-beneficiary, you can receive benefits such as welfare and other rob Peter to pay Paul token benefits such as retirement benefits, unemployment insurance, and other trinkets doled out in exchange for having, like Esau, sold your birthright for a bowl of porridge. There is no grantor or trustee, although there is a creator to a public charitable trust, because it is an implied trust. In other words, constructed and not formed by express written bilateral contract. Once you are in the public charitable trust, you can contract into Social Security, which is a reversionary, revocable trust in the New Deal, a socialist, communist scheme in which all participants are tortfeasors who secure by membership benefits to which they are not entitled by having been extracted at legal gunpoint from other people. Accepting Social Security or any other government benefits is accepting stolen goods, providing the system with an excuse to consider you guilty until proven innocent. Therefore, in any court case, the action is being brought by the allegedly offended beneficiary, the plaintiff, as implied co-beneficiary of the public charitable trust, against the defendant, the implied co-trustee. This is why the law and facts are all completely irrelevant. If you go into court trying to argue either, you must necessarily lose, since the only issue is whether your straw man faithfully performed its duty as trustee of the trust, such as to obey the statutes, pay the taxes, or whatever else is required in accordance with the ever-increasing ocean of bylaws of U.S. Incorporated. If you raise objections of law or facts, you not only traverse and dishonor by arguing, and therefore automatically lose, but you give witness testimony against yourself that you are a bad, delinquent trustee trying to escape your duties as co-trustee of the public charitable trust. You're thereby presumed guilty. Your fatal error is not first and foremost that you argued, denied, rebutted, traversed, dishonored, and try to avoid your contractual and fiduciary obligations of a contract you ratified countless times by accepting innumerable government benefits such as Social Security, obtaining a driver's license, getting a passport, etc., 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 as co-trustee, but that you failed to rebut the presumption that you are the co-trustee, in other words, the same as the defendant's strawman citizen. This is why there's only one issue, and all the rest is so much irrelevant froth. The issue is whether or not you rebut the operational presumption. If you do not, nothing else matters. The presumption, where the power and teeth are, stands and you lose. Number 2, you as the living principle are real and exist on the substance private side. The straw man, all caps name defendant, is fictitious and exists on the imaginary public side. The living principle cannot be seen, addressed, or dealt with by the public side, which is a reflection in the mirror and a chimera. The defendant cannot enter or access the private side, just as the living principle cannot enter the public domain. Number 3, it is essential to neutralize the presumption by which the system operates against us, which is that the living principle is presumed to be attached to and united with the straw man, so that whatever is done to the straw man is imposed in the flesh on the living principle. It is the unrebutted presumption of the union of the real and fictitious that enables the court to access the real you. This is why it is crucial to neutralize the presumption and render it inoperable. Number 4, you must not traverse or dishonor. You cannot win by arguing in let's pretend mirage land. Number 5, you must end the controversy. In other words, terminate the presumption of the existence of a dispute on both the private and public sides. The obligation/charges must be discharged so that the books balance and you have complied with the law in both domains. Number 6, the public side is bankrupt, has no capacity to execute a sentence, and cannot charge you in common law. The charges are in the nature of, meaning colorable, civil or criminal charges in common law, meaning they are in form only without any other substance. This is also, among other reasons, why you cannot lien public officials. Doing so is a common law substance process, and as bankrupt entities, they cannot provide you with a remedy. Trying to lien public officials is a dishonor and crime by endeavoring to impose a common law remedy in a sphere that cannot access common law. Several possibilities in lieu of or in addition to the 3-question approach below for dealing with the name issue come to mind. These statements are intended as satisfying all of the above essential elements. When your strawman's name is called or the judge asks you for your name, you could say one of the following, whatever you are comfortable with. I am here concerning that matter, or I am here as a third-party intervener in that matter appearing as authorized representative for my client. Footnote 21. The third-party intervener is you, the living principle, acting in your own interest because you have a pre-existing claim against the defendant that precludes them from acting against any version of your all-caps name based on your prior contract with them, such as your UCC specified power of attorney and indemnity and hold harmless agreement, your employer ID, etc. Then continue. I accept for value and return for value all the charging instruments in this matter and make my exemption available, not offer, since we can never make offers, for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. We must remember that problems are not solved on the level of problems. We cannot resolve the imaginary dispute in the imaginary domain. We must not try to pay with public funds. We must not try to prove ourselves innocent. And we must not plead not guilty, which is arguing, traversing, dishonoring, and telling them that you are joining the imaginary game and treating it as if it were real. All attempts to do these things are traversing and dishonoring, breaking the law and committing treason against the equity court by trying to deal with the dispute as if it were substantive, private, real, and in common law. The court then convicts us for contempt of court and imposes the common law sentence. We must also remember that they need us as the living principle to be a witness against ourselves, testify, and make the legal determination for them that we are the one they are looking for in their let's pretend game and want to prosecute, convict, and punish. They need us to volunteer into contracting with them in their public domain. They cannot make the legal determinations that the defendant has anything to do with us. It is up to us to hang ourselves. The above statement satisfies all the essential criteria as follows. Number 1, the catch-22 of the matter is that under common law, you're presumed innocent and still proven guilty, whereas in the admiralty equity courts, you're presumed guilty until you prove yourself innocent, which is impossible in their let's pretend presumption game. If you try to prove yourself innocent, you are in dishonor and are charged with a breach of trust to the beneficiary, the state. By so doing, you commit treason against the court by trying to secure a common law remedy where none is possible, and you do not neutralize the presumption and indeed ratify its force and effect while admitting that you have been a delinquent trustee and acted in violation of your fiduciary duty. Footnote 22. An interesting property of their equity courts is revealed by remembering the maxim of law that anything inside a box is not there. Consequently, the following persons/players are not there. Number 1, the jury, which sits in the jury box. Number 2, the witness, who gives the testimony in the witness box. And number 3, the judge who sits on a platform, which is also a box. Only the trustee, defendant, and beneficiary, state, are there and relevant to the proceedings. All the rest are part of the wizard's smoke and mirrors light show of diversion and misdirection. 2, you as the living principle on the substance private side are speaking on behalf of, but not as, your straw man defendant. Ideally, you have filed before ever going to court your court bond and notice of acceptance, standing, and status. Request for remedy, wherein you attach your accepted and return for value documents and your standing status documents to define and clarify your standing as a living principle and authorized representative for your juristic person, ins legis straw man. Number 3, by proceeding in this manner, especially when supported by your notary witness documents, you neutralize the presumption that you are attached to and united with your straw man. Number 4, do not traverse or dishonor, thereby disarming and diffusing the matter. Number 5, you end the controversy by your acceptance and return for value, filing the bond and stating that you are not disputing the facts in the charging instruments. By not disputing the facts on the private side, you remove the dispute at its origin and leave nothing to resolve in the public arena. By making your exemption available to discharge the charges, you are in harmony with the law, leaving no violation to prosecute. Technically, you could say, as the living principle, I do not dispute the facts on the private, substance side, and my client pleads guilty to the charges on the public side. The point is that if you end the controversy on both the private and public sides, there is no dispute for a court to hear and entertain. There is no one and nothing to prosecute. Then, if they wish to convict your straw man of something, let them find the straw man guilty on their own, leaving them exposed. They're welcome to put on a piece of paper with the defendant's all caps on it on the electric chair, throw the switch, and discharge the charges through the paper while you're out having dinner with your girlfriend. Footnote 23. The authors have never heard of this being done, so cannot vouch for the results that might accrue from doing so. Since this statement is accurate, explicit, and addresses both sides of the bar, it theoretically should be effective. Number 6, by not traversing into their game and by not trying to defend yourself or your straw man against the charges, you do not enjoin the substantive private common law side with the civil or criminal charges and thereby become a victim of sentencing as a result. The intent of using the above approach is to truncate the time, effort, and dialogue involved in dealing with giving one's name in court. If you are in this situation and it looks as if it is not getting the job done and getting you the closure you desire, you can at any time go to the 3-question approach discussed below. Placing evidence in court. In the meantime, if you are in a court proceeding, although no one and nothing operating from the public side, in other words, all attorneys and government officials, can place actual evidence on the record, you, as the real being, especially with a notarial witness, can. People and documents you can subpoena for deposition and evidence in your favor include the following. A. In both civil and criminal cases, subpoena persons for deposition or bringing in documents you require as evidence in the case. These parties can include the mayor of the municipality as well as the risk management accountant of the municipality, with documentary proof that the insurance books on the case have been adjusted and a bona fide assessment has been made of the bond, the original complaint filed in the court. The voucher that must be issued by the Department of Risk Management of the municipality in which the court is located is to monetize the complaint that created the funds by utilizing the derivative name, the all caps name of the defendant, supported by municipal bonds. Serving as subpoena ducis tecum, hereinafter SDT, whether or not you depose anyone for direct questions is appropriate in both state and federal cases. Obtain several official stamped subpoenas from the court in advance. In the section asking for documents subpoenaed, print, see attached schedule of documents subpoenaed set 1. You can have your subpoena ducis tecum served by a process server, sheriff, or U.S. Marshal and serve the prosecuting attorneys and perhaps also the mayor of the municipality in which the court is located and the head of the department or accounting department of the municipality Department of Risk Management. The documents you should subpoena and require them to provide you with are as follows. A. Civil. 1. Basis upon which prosecution concerning your case number may continue after authorized representative has accepted and returned the charging instruments and case for value and posted a bond secured by and through authorized representative's exemption, and therefore discharged the obligation and ended the controversy. Number 2, certified copy of the assessment in fact on which the charges in regards to case number are based. And number 3, a certified true copy of the order from the Secretary of the Treasury to collect the debt obligation of the defendant for the case number. And number 4, a certified audit trail of the voucher for monetizing the complaint/bond on the case. B. Criminal. All of the above items for civil plus, number 1, the detainer authorized an incarceration of the defendant and the accompanying physical body of the name, your name, of the case number. Their failure to provide any of these items is a tort and grounds for habeas. As for the evidence you wish to establish on the record, first file what you want judicially noticed as evidence. This should include your court bond. As soon as your documents are filed, obtain at least 2 certified copies from the clerk of the court. Keep one set in a safe place. Take the other set with you to place into evidence in open court. Once you serve the evidence on the court, it cannot be denied. You give your documents to the bailiff who serves the judge, and even if the judge throws everything back at you, it does not matter. What you want to put into evidence has been served. The documents for you to file in the case and serve on the judge in open court should include the following. Number 1, the judge's oath of office that you received from the Secretary of State or whatever official source provided it to you. Number 2, your court bond that bonds the case. And number 3, proof that you accepted the case and all charging instruments for value and returned them for value. Number 4, your judgment and estoppel of the law, first certificate of non-response that the notary served on the opposing parties. And number 5, your judgment and estoppel of the facts, money, second notarial certificate of non-response.